Okay, well, good morning, everybody. Welcome to Avoiding Misconduct in the Heat of Trial. Trials move at you quickly, and that's what we're aiming to do today, is run through a rapid-fire approach to going through the ethical rules and how they apply to trial lawyers and where problems tend to arise in the heat of trial. One of the caveats of this presentation is because it's a nationwide audience, we'll be focusing on the ABA model rules, but you do want to make sure that whatever rules in the state you're practicing in, you follow those, and those sometimes vary from state to state. Our presenters today are Ronald Minkoff, who's a partner at Frankfurt, Kurnit, Klein, and Selz in New York. Alanna Clair, a partner at Dentons in Washington, D.C., and myself, Michael LeBoff. I'm a partner at Klein Wilson in Newport Beach, California. All right, so let's jump right into this and start going through the ethical rules. And the first one at the top of the list is Rule 1.1, which is the duty of competence. All right, and what does the duty of competence say? It says a lawyer shall provide competent representation to a client, not too much of a surprise. And competent representation requires that legal knowledge, skill, thoroughness, preparation reasonably necessary for the representation. Now, what does this mean in connection with a trial? First of all, and I think it's important to point out, that competence doesn't mean perfection. Right? You are not ethically required to be perfect. And in fact, I would dare say that I don't think the perfect trial has ever been conducted. Even in a trial where you have great success in the verdict, you could walk through that trial and find a bunch of different things you should have done differently, objections you didn't make, objections you made and shouldn't have, questions you didn't ask. So competence does not mean perfection. And I think that's an important point to take home. The other thing about the duty of competence as it relates to trials is it doesn't start the moment you show up to trial. The duty of competence for a trial lawyer really starts the moment you've taken on the case and made sure you've done the trial prep work. So when you get to trial, you're not finding that you messed something up or missed something or run into an issue. One of the hardest things for